Now I am going to dictate judgment of MALDA District Court at the rate of 120 words per minute. Let's start. In this petition, under Article 32 of the Constitution, the petitioner questions the validity of his detention under the Maintenance of Internal Security Act 1971. He was arrested on July 14, 1972 on the strength of an order made on the previous day by the District Magistrate MALDA, West Bengal. In exercise of the power conferred by subsection within bracket 1 read with subsection within bracket 2 of section 3 of the said act, the order directing the petitioner to be detained said that the District Magistrate MALDA was satisfied that it was necessary so to do with a view to preventing him from acting in a manner prejudicial to the maintenance of supplies and services essential to the community. The grounds of detention served on the petitioner mentioned the following particulars which apparently satisfied the detaining authority that it was necessary to take the petitioner into preventive custody. Para. In the petition, the petitioner has denied the allegations against him. He states in paragraph 3 of the petition that the MALDA police arrested him on some criminal charge and produced him before the sub-divisional judicial magistrate MALDA, but as the local police failed to produce any material or witness against him, he was discharged, and that the detention order is based on the same allegations. He submits that the detaining authority had acted mechanically and had not considered the merit of the case. Para. The affidavit in opposition filed on behalf of the respondent State of West Bengal in answer to the rule Nishi issued on the petition has been affirmed not by the District Magistrate MALDA on whose satisfaction the order of detention was based, but by the Deputy Secretary Home within bracket Special Department Government of West Bengal. It is stated that the District Magistrate was not available for affirming the affidavit as he was very busy and preoccupied with maintenance of law and order situation in the district of MALDA. With reference to what the petitioner has said in paragraph 3 of the petition, it is stated in paragraph 6 of the affidavit in opposition that in respect of the two grounds of detention, two criminal cases were started in the court of the sub-divisional judicial magistrate MALDA on July 3 and July 6, 1972 under section 147/461/379 and section 461/511 respectively of the Indian Penal Code, and that the investigating officer who was in charge of the matter had informed the dependent that as no person was willing to give evidence against the petitioner in open court, the petitioner was discharged from the said cases. Para. It now seems established on a series of decisions of this court that the jurisdiction to make orders for preventive detention is different from that of criminal courts seeking to punish the accused for an offence depending on the subjective satisfaction of the detaining authority and the other on proof beyond reasonable doubt, and that unsuccessful judicial trial or proceeding would not operate as a bar to a detention order or make it malified. The incidents which formed the subject matter of the two criminal cases against the petitioner also constitute the basis of order of the detention. The fact that the petitioner was discharged from the criminal cases does not necessarily prove his innocence, but it certainly does not indicate that he was involved in the incidents described in the grounds of detention. The statement in the affidavit in opposition that the petitioner was discharged because none was willing to give evidence against him in open court is based on information given by the investigating officer to the Deputy Secretary, who affirmed the affidavit, but the Deputy Secretary is not the detaining authority. The district magistrate on whose subjective satisfaction the detention order was made does not come forward to say that he had also received similar information from the investigating officer which he believed to be true, or that he had other material to convince him that the petitioner was discharged because witnesses were afraid to give evidence against him. In the petition, the petitioner has suggested that witnesses were not available because there was no material against him. Counsel for the petitioner pointed out that in the incidents of the 2nd and 3rd of July 1972 described in the grounds of detention, the petitioner and his associates are said to have come into clash with the members of the Railway Protection Force, and on July 3, the on-duty RPF personnel, it is alleged, managed to arrest the petitioner and two of his associates red-handed. It was submitted that it was difficult to believe that the members of the Railway Protection Force would be afraid to give evidence against the petitioner, and that the detention order in this case was passed mechanically and was a colorable exercise of the power conferred by the Act Para. We do not think it can be said that the fact that the petitioner was discharged from the criminal cases is entirely irrelevant and of no significance. It is a circumstance which the detaining authority cannot altogether disregard in the case of Bhutnath Mete versus State of West Bengal. This court observed